Hello, good evening. I am Leanna Sanders. I'm a family navigator for families of kids 0 to 11 years old. And tonight's webinar is going to be about state and federal benefits with Bhavik Patel.
Thanks everybody for joining. And, you know, we're going to talk about state and public benefits. I'm going to share my screen here in a second, but I'm just going to kind of lay sort of the roadmap for today. Ultimately, what we're going to talk about today is understanding the eligibility rules of public benefits. And we're going to talk about what are the public benefits that are really relevant, and there's a lot of them, but we're going to talk about the four main core public benefits, and sort of understand how to get those benefits, how not to lose those benefits, and so creating sort of this very solid foundation. But it's just a foundation. It won't have all the details or all the specifics for every unique issue. As I'm talking to a larger audience today, I just wanted to make sure that at least we have a very good understanding about the foundation of public benefits and what the benefits are and how not to lose them if you are planning on receiving those for your loved one. Another thing is I will often talk about your loved one with a disability. And instead of keep saying loved one with a disability, I'm going to call that individual Joey. So, when I say Joey, that's who I'm talking about. And it just allows for the conversation or the presentation to be a little bit more personalized and hopefully can register. First of all, just an introduction of me for those of you that might not know who I am. My name is Bhavik Patel. I am an estate planning attorney and a special needs planning expert in this region. I think I've given over 100 or so of these presentations to ARC family. So really appreciate being here and thanks for listening in. Let's talk about the funding. Okay, there are two ways to fund or provide funds for Joey. The first way is not about public benefits, but it's private funding. It's not going to be the area that I'm not going to spend much time at all talking about it. I would encourage you to work with financial advisors or CPAs or insurance folks in your world to help guide you on what you can do to provide private funding. Private funding, in essence, is what the family leaves for Joey to better help supplement Joey's needs, whether that's life insurance or savings and by way of your inheritance, those types of things. It is what's going to supplement the public benefits that you might receive for Joey. We won't spend a lot of time talking about special needs trusts today, but I want you to know that we have multiple presentations on that topic throughout the year on special needs trusts, and I would encourage you to join one of those so that you can learn a little bit more specifically about the value of special needs trusts. Now let's switch gears to public funds. So public funds are benefits set aside by the federal government and state government to be used for the care for Joey. These funds are meant to be used, and there's no reason not to take full advantage of them. And the reason I'm saying that is that I see families all the time, and they tell me, well, I don't know if we should get public benefits. I feel bad receiving them when I have maybe some other means to help, and so on and so forth. I tell folks all the time, you're already funding these benefits through your jobs, through taxes, whatever. And these are meant for everybody to take full advantage of. And I would encourage you to be, if it makes sense for your Joey, to be able to then take advantage of it. And we're going to talk about how to do that here in a second. First, let's talk about the two broad categories of financial public benefits basics. Okay, on the column on the left that you see, ultimately, there are benefits out there that are not based on financial need. So benefits not based on financial need is one sort of category of public benefits. The other side of that slide there is public benefits based on financial need. So you have those not based on financial need and those based on financial need. Those are really, I mean, these aren't like legal categories. These are just the way I categorize the two public benefits kind of categories that are out there. On the side that's not based on financial need, we're talking about good old fashioned Social Security. The same Social Security you would receive once you hit the retirement age and you had earned enough credits into the system. And then Medicare, which is medical insurance for your medical care. You also have something like special education and things like that that are non-financial need. We're not going to spend much time talking about special education, but we will talk about Social Security and Medicare through this presentation. On the other side of the column is those based on financial need. You've got your housing subsidies like HUD housing, Section 8 housing, food stamp, legal aid, utility payment assistance. Not going to really talk about those, but there are types of public benefits out there that are there to help those with financial need. The two we are going to talk about a lot today is supplemental security income, or otherwise known as SSI, and Medicaid. And we're going to talk about those today as financial need-based public benefits. Let's start with SSI, supplemental security income, not Social Security income, not Social Security disability income, and not Social Security at all. This is supplemental security income, and I apologize in advance of why they have to use the same letters. Why do they have to? Because it causes a lot of confusion. The first thing about SSI that I want you to be aware of is it's a federal program, but it's administered by the states. You'll get to know my humor through this conversation, but what that really means is that it's pretty chaotic. It's federally funded. It's federal program like that because it's federally funded, but it's administered by all the states, and all the states have different ways to administer it. And then even within a state, you might get a variety of consistent or inconsistent answers depending on who you're talking to within the state office. What all I have to say is, yes, it is frustrating. It is chaotic. You could have exactly the same situation as your neighbor. Both of you apply on the same day with the same exact scenario, and you might get a slightly different benefit from each other. And there's, I guess the best way I could say is, it's definitely not a perfect system and it's very messy, but it's still a system that can provide tremendous value to Joey and help Joey meet certain needs that he might have, that would allow for the private funding side to supplement or to provide additional value or support for Joey. So no, it's not a great system, but it's our system and it's the only system we have. So there are two big elements that you must prove in order for Joey to receive SSI benefits. Joey must prove that he is disabled. That is done by medical evidence. So if you apply for SSI, through that process, you will be approving the state in getting access to Joey's medical records so that they can evaluate and see if that part of this two-pronged test is met. So Joey must be disabled in order to receive SSI. The second element is Joey must prove financial need, that he has financial need. If Joey is under the age of 18, then not only does Joey need to establish financial need, but his parents must also have to establish financial need. And if the parents are married, it would be them collectively. If the parents are divorced, it's them individually, even if they're remarried and all of that. So all of that gets looked at if Joey is under the age of 18. If Joey has reached adulthood, transition from child to adulthood, which is 18 years of age, then they will stop looking at the parents' financial need and they will solely focus on Joey's financial need. We'll talk a little bit more about the financial need tests and what really needs to be passed in order to be eligible for that. But let's assume for a moment Joey receives SSI. SSI is a monetary amount of money that could come in monthly that can range from 0 to approximately $900. That's your range, okay? And some people can get that maximum amount, and some people get something below that maximum amount, depending on some of the things we're going to talk about here shortly. But more importantly than the amount is SSI money is known as restricted money, meaning it must be used for very specific purposes. In particular, SSI should be used for food for Joey and shelter needs for Joey. So paying for rent, where he lives, paying for certain key utilities to allow for where he's living to function, and then for his food, groceries, restaurants, things like that. This is very important to understand because so many of my clients will get the SSI money for Joey and will start spending it for a variety of things, pencils, for example, or paper, or things like that. And though those are all important, needed things, that's not within the rules of SSI. And so if the state decided to audit Joey's benefits and his use of benefits, or if if they had somehow figured out what was going on, that would jeopardize these benefits. So I just wanted to make sure you understood that SSI money should really be limited to food and shelter.
Can SSI be used for a nursing home?
SSI money is if they're living in the nursing home, that is part of shelter. A lot of times when Joey is in a nursing home, all of the SSI will be allocated to the nursing home, which will then credit it whatever amount the expenses are for Joey. They'll credit the SSI amount. They won't even give you a choice to use it. They'll require that they have to take it. And then they'll hold on to the account and the money and use it accordingly to the services. And then after that, potentially if Joey's on Medicaid, then Medicaid services would kick in and pay the rest.
So how are SSI funds tracked?
So it's no different than your tax returns. I mean, at the end of the day, we're a self-reporting, self-policing sort of government in this sense. So the risk is audit risk. And if you were to ever be audited, they will ask for receipts and records and things like that. And if they're not satisfied, you'll lose the benefits, and the penalties could be severe. If they find that the benefits were used inappropriately, you may close the door to benefits, or be asked to return the benefits, meaning to pay them back all the way up to the full amount. So it can be very severe penalties or uh, future suspension of benefits. So but it is practical to some nature because as you can imagine, not everybody gets audited. Just like the IRS, they can't audit every tax return. This is really no different. It's really difficult to audit every individual receiving a benefit. Now, you are filling out an annual report to the state saying that you have um, used it appropriately and so on and so forth. And so they could get you on even stiffer penalties that deal with perjury issues or things like that. Let's talk about financial need. In essence, there are two tests that determine or that factor into SSI. And if there's one takeaway out of all of this today, this is it. And I'll use a sort of a silly analogy that hopefully you can visualize to help understand how these two tests sort of work together to the land of trying to receive public benefits, and in particular SSI. So picture yourself in front of a locked door, and on the other side of the door is SSI benefits. Well, there are two tests. Let's say one test is the test you have to pass to unlock the door. And then the other test is the test you have to sort of pass to decide how ajar or how wide open the door is going to be. So let's talk about unlocking the door, because you can't open the door if it's locked. You can't receive benefits if that door is locked. When I say locked, I'm really just talking about eligibility. How do you become eligible for SSI? So that test is known as the resource test. And when I just read the name of a test, I become curious. Resource test. So to me, naturally, the first question I ask when I read resource test is, well, what is a resource? I'm going to talk to you about that here. Let's start with a very broad, overly encompassing definition of resource. Anything that can be converted to cash is a resource. Anything that can be converted to cash. It doesn't matter how much cash, it just means that it can be converted to cash. So we're talking about the clothes we wear. Now I'm going to give you some exceptions here, but I want you to start with very broadly, a resource is everything. It's anything that Joey possesses, owns. And mind you, I'm talking about Joey after he's an adult. If it's before he's 18, they also look at the parents' resources. That's a very, very high threshold to meet and get SSI payments while your child, Joey, is a minor. So, what exactly is the resource test? What is the number? If Joey's resources exceed $2,000 on the first day of the calendar month in which Joey applied for SSI. So it's May 16th. And if Joey applied today, they would go and look at what Joey's resources were as of May 1 of this month. And they would add up anything that can be converted to cash And if it exceeded $2,000, the door would be locked, meaning no way to open it, no way to receive SSI benefits. The other thing I'm going to say is, even if at one point you had the door unlocked, and then resources came to Joey after I applied, you in essence have till the 1-year anniversary to make sure you continue to pass the resource test year over year. I would not, however, encourage you to go from $1,000 on the first day, ramp that up to $10,000, and then figure out a way to get it back to $1,000 on the 1-year anniversary. Maintaining public benefit eligibility requires an ongoing discipline of making sure you're not coming close to locking the door, that you're not coming close to violating the resource test. Later on, we're going to talk about Medicaid, and Medicaid has a resource test as well. It's a higher threshold. It's $5,301 for Medicaid eligibility rules for the resource test. I don't want you to ever remember the $5,301. I truly want you to only, even though it's technically not correct, and if you go and talk to friends or talk to a neighbor and you say, I went to a presentation and he said this, and it's technically wrong, I admit it. It's just a safer way to go about it. I only want you to think about the lower number. I only want you to think about the resource test being $2,000 for both Medicaid and SSI. It does you no good to remember the $5,300 number if you're still trying to get the SSI. Okay, remember I said that we're going to start with saying resources is everything. Let's now kind of walk that back a little bit. There is by law certain assets or categories of assets that are not considered resources or are just excluded from the calculation. The first one is a home. If Joey has ownership of the home and he actually lives there, then the entire value of the home is exempt from the resource test. So in other words, Joey could have $100 in the bank, nothing else, and a $500,000 home that he lives in, that he owns. And Joey would still be eligible and would still pass the resource test. Now, this does not mean I want you to take away from that I'm just going to leave my house to Joey when I pass away because it won't disqualify him from public benefits. That is not a part of what we're talking about today, but it's not a good strategy to leave the home to Joey for a couple of reasons. If Joey ends up not being able to live in the house because he needs to go into that nursing home or a group home, or he just needs some more care and he can't live in that house, the moment he no longer lives there, it becomes an accountable resource. And so the $500,000 home now puts you above the threshold, you lose the benefits. So that's one reason why I don't think it's a good strategy. The second reason is if Joey did own a home and then he died, the government, the state, will be able to attach a lien on the house to recoup the costs that it spent for Joey's care. That's called a Medicaid lien. And so through better planning and a more thoughtful planning, leaving the house in a different way for Joey to live there would avoid the lien, which would allow the house then to go to other family members upon Joey's passing, or allows Joey to go in a nursing home and not lose his benefits because he owns this house. Those are much more optimal or proactive strategies. Nonetheless, the law allows you to exclude the home that he lives in for public benefit eligibility or resource test component. Household goods. These are all the things, the stuff, things that don't have title. I will tell you, the state doesn't focus too much on this, but the actual law is household goods in the aggregate not worth more than $2,000 of current fair market value. The problem and the reason why the state doesn't focus too much on this issue is because it's hard to prove who owns the stuff. I mean, it's hard to say Joey owns the iPad versus mom or dad. It's just very difficult. So you could always just say mom and dad own it, not Joey. And now the iPad's market value isn't counting towards the 2,000. Nonetheless, I just wanted you to be aware of all the exemptions or exclusions from the resource test. But this is one I wouldn't really focus too much on. The next exclusion from the resource test, which is a morbid sort of asset, but a prepaid funeral. If for whatever reason, let's say Joey had more than $2,000 and so the door was locked, Joey might consider, or Joey's guardian or someone on behalf of Joey might consider to use the money that's above the threshold and maybe pay for a burial plot or a burial space or a prepaid funeral, thus allowing that asset to still stay in Joey's column, but now be an exempt or an excluded resource versus the money that was sitting in the bank account. And so that's an effective strategy in the event that you need to react because you're above that dollar amount threshold. A few more exemptions or exclusions. One is a vehicle, as long as the vehicle does not have a current market value in excess of $4,500. So, I mean, again, my humor, a relatively unsafe vehicle, potentially, or a used vehicle that obviously is dated now for it to be a fair market value of $4,500. However, there is the allowance to have a vehicle that is much more expensive, as long as that vehicle is necessary for the employment or medical treatment of Joey, or it's necessary to perform essential daily activities, then it no longer has that current market value. What I'd tell people is think about like one of those handicap accessible vans. They're customized. They can be as expensive as $100,000, but they could be necessary to transport Joey. Maybe because he's in a wheelchair and he can't walk, as a way of an example. So I just wanted you to know that there is the ability to have a more expensive vehicle, but you have to qualify for one of these exceptions to the $4,500 rule. A life insurance policy that is owned by Joey that has a cash surrender value of less than $1,500. Mind you, this is an insurance policy owned by Joey. So, keep that in mind. This is not a very broad exclusion. These are for particular, what I see it applied to a lot of times is for adults that have become disabled and perhaps already had life insurance in their name. And then if that had cash value above 1,500, it would keep the door locked to public benefits. The last two are not technically in the resource test rules, but they apply because they've been added in other laws that would allow you to create an exemption or an exclusion from the resource test. The first of those two is an ABLE account. An ABLE account is essentially a savings account that Joey can utilize with Joey's assets, or other people can put assets into it. You're limited on being able to save about $15,000 a year into the ABLE account, and the total value of the ABLE account must be under $100,000. So there is an amount to be able to save, but if you save too much, it's going to go back to locking the door. Now, I'm not going to talk a lot about the ABLE account, but I will say in general, the ABLE account would then be allowed to be used for Joey's benefit to take care of him, to supplement his needs. So very similar to a special needs trust, and how a special needs trust can be used for Joey, an ABLE account works the same way. Now, I don't want anybody listening to me to go set up an ABLE account for Joey tomorrow, unless Joey has assets in Joey's name, or he's working and so he's making money. Those are the types of things I would put in an ABLE account. Assets that are already in Joey's hands, or part of his salary, and he's accumulating his paycheck and it's starting to save up and it's getting close to the threshold of 2,000, then moving the amount into the ABLE account is a very effective strategy. I am not a big fan of mom and dad putting mom and dad's money into an ABLE account, or putting really anybody else's money other than Joey's into an ABLE account. And the reason for it is Medicaid can also attach a lien on any leftover money in the ABLE account. So I'm kind of a have your cake and eat it too kind of guy. I would rather figure out a different way to save mom and dad's money to provide for Joey, but have it outside the reach of a Medicaid lien or some other kind of reimbursement to the state. And the last one is assets placed in a properly drafted special needs trust. There are, like I said earlier, we have 2 other seminars that talk specifically and only about special needs trusts. So I'm not going to elaborate beyond that. But suffice it to say, there are many different types of special needs trusts. You need to understand those different types of special needs trusts, and you need to understand whose money can go in which type of special needs trust. But for purposes of unlocking the door or having the door locked, assets in a special needs trust will not lock the door. So there could be $10 million in a special needs trust for Joey, and outside that special needs trust, Joey has literally no other assets. Joey's door is unlocked.
We have a question.
Okay.
This person is saying, my daughter, age 17, receives SSDI benefits on my record as a minor child. since I'm receiving Social Security retirement benefits. My daughter has an intellectual disability and will be turning 18 this September.
Okay.
She will still be a full-time student. Should she apply for SSI at age 18 as a disabled child benefit?
I would not replace SSDI until you have to. So as long as the SSDI payment continues, I wouldn't worry too much about the SSI payments. That'll come into clarity here when I get to SSDI, but just for purposes of answering the question, SSDI is unrestricted money versus SSI. So you have a lot more freedom in what you can use the money for. And so why close that chapter to open up a chapter that's actually more restrictive? Now, eventually SSDI will run out unless you're eligible for SSDI even as an adult. Right now, you're getting a minor child SSDI. I would keep that until that expires, and then I would consider whether your soon-to-be adult child could still apply for adult disabled SSDI payments. And if that's the case, then I would never touch SSI. If for whatever reason your adult child is not going to receive adult SSDI disability, then it would be at that time that I would apply for SSI. All right. So we have talked for quite a bit here on the issue of unlocking the door. But now let's shift gears to talk about how wide the door can be open. And so we look at the other test. That other test is known as the income test. And again, just like when we were talking about the resource test, we said, hey, a natural, obvious first question is finding out what resources are. Well, when we're talking about the income test, I think we should be asking ourselves, what is income? And there are three categories of income. The first one, the one that makes the most sense, is the easiest to comprehend. It's called earned income. And so that's like, clocking in and out, earning a paycheck, your salary. Those are the types of things that are called earned income. So if Joey's working, he's earning income, and that will be a factor in how wide the door is open. Another type of income is known as unearned income. So that's like alimony or child support payments. I'm going to spend a second talking about that. For any of you on this call that's divorced, when you go to your divorce lawyers and you go through and get a divorce, they're not special needs or public benefits experts. And so they're negotiating a child support payment, or whichever party they're representing. And ultimately, it has led to more loss of benefit. This is one of the ones that leads to a loss of benefit more than almost so many other things, because they have a child support order. Joey's getting $1,000 a month. The moment Joey turns 18, that child support money is deemed unearned income to Joey. And so that could be a problem. That could end up closing the door, so to speak, which is problematic. There is a way to fix that issue. If you're stuck in that issue now, it does involve, in a perfect world, cooperation from an ex to be able to resolve this jointly. And hopefully they're able to put personal differences aside and think about Joey's best interest. But that's not often the case. You could modify or it could be done by actually fighting about it in court, but hopefully by agreement. But ultimately, you would ask the court to modify the child support order to allow for that child support payment to be put into a very specific kind of special needs trust, which would then allow for the benefits to continue while still receiving child support payments. But unfortunately, it's a big area where we see people losing benefits. Another one that you see on that screen there is payments of other benefit programs. So that question about SSDI, that SSDI money that Joey's receiving is going to be unearned income to Joey, which will reduce or eliminate the ability to get SSI money. Otherwise, it's, it's interest earned on your checking account, things like that is unearned income. But the last type of income is the one that surprises people, doesn't expect it. It is called in-kind income and also often referred to as imputed income. The biggest example of in-kind income is if your adult child is living with you rent free, then the state is going to determine some number of imputed income, because otherwise an adult would have to pay to live somewhere. You have a legal obligation to house minor children. You no longer have that legal obligation as an adult child. And so therefore the law says if they're living with you and they're living rent free, then that's considered income. And so we don't need to give you as much SSI money, because SSI money is for shelter, rent, and food. And if you're already getting that for free, I don't need to give you the maximum amount. That's the logic. That's the thought process. I bet you many of you listening in have heard the concept or are already fulfilling the concept of your Joey, who's an adult, paying rent to you as the landlord or the owner of the house that Joey's living in order to avoid this in-kind or imputed income characterization. This is what will also allow you to help maximize how wide the door is open, how much of an SSI benefit Joey's going to receive. I did not give you a very specific formula for the income test, and I'm purposely not going to tell anybody about that test. One, it changes very frequently. Two, what I want you to hear is any amount of income. Here's what I want you to remember. Income, any kind, any one of these categories, is going to start to close the door. So no income, doors wide open. Suffice it to say, let's say more than, this is not an actual number, but this is the number I want you to remember. More than $1,000 a monthly income, considered a door shut. So 0, wide open, 1,000 shut. That doesn't mean $500 of income means the door is going to be open halfway. And that's why I'm not going to share it. I just want you to correlate Joey's income to being wide open or closed. Okay, so I'm going to pivot from the SSI eligibility rules. But before I pivot, I just want to summarize. You must pass the resource test in order to unlock the door. You must continually pass the resource test in order to avoid the door from becoming locked. If the door is locked, you get no benefits, both Medicaid and SSI. You don't get any of the benefits. If the door is unlocked, you then go to the income test to determine how wide or how much of a monthly benefit you get. That, as I told you earlier, if you take anything from what we talk about today, that's it. Remember the resource test and the income test and the roles that both of them play as it pertains to this analogy of a locked or unlocked door. I'm going to back up for something very specific. As we were talking about the exemptions or the exclusions from the resource test, the exclusions I went through is an exhaustive list. It's not an illustrative list. Another way to say it is if I did not specifically mention it being excluded from the resource test, that means it is included in the resource test. And I say that because oftentimes I'll get questions, I have a 529 or I have a this, do those count? I have gone through every single exclusion. There are no other exclusions I didn't discuss. So I did not mention a 529 plan. I did not mention a CD that my grandmother might have given Joey. I didn't mention any of that. It means those things are included in the resource test. I just wanted to kind of very specifically highlight that is the list of exclusions. Okay, so we talked about SSI, which was a financial need-based category of public benefit. Now I'm jumping to the non-financial need-based benefit that is known as Social Security benefit. And in particular, Social Security disability income for a disabled child. Not to be overly morbid, but I drive home, I get in a car accident, I become disabled. I have been working my whole career. I've been earning credits in Social Security. And if I become disabled now, I'm going to be able to receive Social Security disability for me as a working adult that's earned enough credits into the system to be eligible for that benefit. That isn't what we're talking about today, but I wanted you to know that obviously is the thing that I think most of us know or are familiar with or appreciate. But there is another benefit for Joey, an adult Joey, where Joey is eligible to receive SSDI that's tied to my Social Security. Very important. A lot of people do not know about this. Here's what has to be proven in order to have Joey receive mom or dad's a portion of mom and dad's Social Security. One is Joey must be disabled prior to the age of 22. Obviously, again, medical records. This is medical substantiated. They'll have access to your doctors and Joey's doctors and medical records to be able to assess that. There is, however, one more additional definition for Joey's disability when it applies specifically to SSDI. If Joey has the ability to earn income that is above $1,000 a month, that's not an exact number, that's just the number I'm going to say in this presentation so that you remember a specific number. then SSDI is going to deem Joey not to be disabled, even if he's disabled medically. So the ability to earn too much money is also a part of the disability definition in this particular circumstance. And by the way, that makes sense even for me if I were to drive and I got in a car accident, but I was still able to practice law, I won't probably receive SSDI payments for me. Okay, so one test is the child must be disabled prior to the age of 22. The other is that one of Joey's parents must be eligible to receive Social Security, him or herself. And there are 3 ways a parent can become eligible to receiving Social Security, him or herself. 1, if the parent is deceased. 2, if the parent reaches the retirement age and is drawing or collecting on Social Security. Or 3, the parent, him or herself, is disabled and receiving SSDI payments. Social Security is not the decision of Joey receiving SSDI through his parents' Social Security is not affected by Joey's assets. In other words, Joey could have $1 million sitting in the bank, but have been disabled prior to the age of 22, and Joey's mom has passed away. And so then Joey would be eligible to receive SSDI. How much can Joey get through SSDI? Well, it depends on the eligibility standard that's applying to the parent. So remember, the parent's eligible if the parent's deceased, disabled, or retired. If the parent is eligible due to disability or retirement, then Joey is entitled to an amount equal to half of the parent's benefit. So if the parent was receiving $2,000 in Social Security, the parent will continue to receive that $2,000 at retirement or disability, but Joey will receive an additional $1,000 for Joey. Remember, this money is unrestricted money. It can just go in a good old-fashioned money market, a checking or a savings account. It could be saved. It could grow. It doesn't have to be used for food and shelter. It doesn't have to be spent on anything other than what it needs to be spent on. If you're only focused on SSDI. But if you have Medicaid, for example, then you need to monitor how that money is accumulating or being saved so you don't lose Medicaid. You might lose SSI because SSDI is unearned income and it might shut the door. It doesn't lock the door, it might shut the door. But it doesn't mean that you would lose Medicaid. So I want you to understand there's a lot of moving pieces there, but I wanted to make that sort of broad statement for you to kind of understand how all of this works together. By the way, if the eligibility of the parent is determined because of the parent's death, then Joey would receive 3/4. So if that amount was $2,000 for the parent, now Joey is going to get $1,500 a month. And that is a month for the rest of Joey's life. If it was $3,000 that the parent was getting, that's $2,250 a month that Joey would get for the rest of his life. What if both parents are eligible? Do I get the double count? Do I get to get a little bit of from both? No is the answer. They will look at the higher eligible parent, the parent that's having more of a benefit, and they'll base it off of that. Here's the thing about SSDI for Joey as an adult that's different than SSI. Joey will only get SSI if he applies for it. And also, though it's true, Joey has to apply for SSDI, his right to the SSDI money starts at the moment that eligibility is occurred by the parent, and either the parent is deceased or the parent actually starts to receive the money from Social Security. And the reason that's so important, this happens all the time. So many people do not know that this benefit exists for Joey. And it's not like an opt-in right. It's a actual legal right. So it starts the moment it's eligible. So here's what happens all the time. One of the biggest reasons people also lose their Medicaid benefits is because they did not understand what I'm about to say. So picture the scenario of mom or dad retiring and receiving Social Security, receiving $3,000 a month in Social Security, and has been doing that for 5 years. 5 years later, you realize, oh my God, Joey was supposed to get this benefit. So I need to let them know, and it happens. I don't know exactly how it happens, but it has happened. Social Security themselves find out that Joey was to be eligible. What happens then in that 5th year is when Social Security realizes it, they'll be like, oh my God, we owe Joey $90,000. That's what the math led up to being if the eligible parent was receiving $3,000 a month in Social Security. 5 years later, $1,500 a month times 60 months would have meant that Joey would have received $90,000 in total benefit. Here's what's going to happen. They're going to write a check to Joey for $90,000. Well, $90,000 is above the threshold for Medicaid resource test, and you're going to lose Medicaid, which is a very, very important public benefit, which we'll talk about later. And most people want to keep or hold on to Medicaid because of its powerful nature and what it does provide care and funding for. So not only will it disqualify Joey from potential Medicaid, it's clearly going to shut the door for SSI, but it's also going to trigger SSI saying, wait a minute, we've been paying you $800 a month. I'm just making up a number for the last 60 months. So we've paid you $48,000 in benefit that we should never have paid you because you were eligible for SSDI and forgot to tell Social Security that. So we are asking you to pay us back $48,000. So once you do that, the $90,000 of benefit ended up only being $42,000 that you get. By the way, there's taxes on that. So after taxes, it ends up being maybe around $30,000. And then even the $30,000 is above the Medicaid threshold. So you still lost Medicaid. So all I really want, I'm not trying to scare anyone from all of this. All I want you to understand is you need to be very proactive of the timing of when you receive Social Security. And if Joey's disabled prior to the age of 22, that you're communicating all of that right at the same time so you could deal with receiving SSDI payments monthly. And then you can get yourself on autopilot, meaning spending the SSDI money appropriately, so it's not accumulating, so you don't lose Medicaid, or moving whatever is being saved into the ABLE account, like the example we talked about earlier, so that you could save for Joey and not lose the Medicaid benefit.
We have about 5 questions. So the first one, I am retiring in June. I have 2 kids who are disabled and have Down syndrome. Don't they both qualify to get half of my Social Security? And one is 17 years old and the other is 13 years old.
So they will get the minor age Social Security until they age out of that, and then they'll be eligible to get the adult SSDI. But it doesn't automatically convert. So you have to proactively communicate at 18 the shift to the adult SSDI benefit. But yes, both children would get it. Now there is an all-out family cap. So, if you had 10 children with disabilities, you wouldn't be able to get 10 times the benefit. There's a family cap. The family cap's reached, then it's proportionately reduced to all the eligible Joeys. So just wanted you to understand that. But yeah,
Thank you. And then second one, how would all this apply to Joey if someone has guardianship of him through Children's Division?
guardianship has nothing to do with adult SSDI. Just because you're the guardian of someone that turned 18 or older does not mean they're not still an adult. So the real blunt answer is guardianships have nothing to do with the benefits that we're talking about.
And then last question, in the case where the second spouse retires and their amount is higher, thus the benefit for Joey is larger than when the first spouse retired, how do you make sure that Joey is now getting the higher amount? Do you reapply?
Yeah, you proactively communicate with Social Security when the higher amounts being applied for by that eligible parent, and then they shut off the valve of the other one and start the valve of the higher one. Here's just kind of an example of the universe, okay? And this is just a very general example. Example of Helen, who's been disabled from birth, so meaning disabled prior to the age of 22, is receiving $720 in SSI monthly benefit. Now, Helen's father, Earl, retires and receives $1,000 a month. Helen then begins to receive $500 a month in SSDI, which is unearned income to Helen. And forget about the formula, forget about the numbers. This is just an illustrative example. But because Helen is receiving $500 a month in unearned income through SSDI, Helen's SSI is being reduced, meaning the door is closing. And this, just by way of example, is just $480 reduction. There is the possibility in the universe where Helen can receive $240 of SSI, 720 minus 480, and $500 in SSDI for a total of $740. And I get people when they read this example say, well, what's the big deal? Well, first of all, this is just an illustrative example. These aren't real numbers. My guess is the numbers might become or could be bigger. And if so, that is an answer to why it's a big deal. But the other thing I want you to remember SSI is restricted money and is a financial need-based benefit, while the $500 is not restricted money. $500 could be for movies and vacation and books and other fun things that could be very meaningful in Joey's life, but the SSI is for food and shelter. So I just kind of wanted to give you this sort of example of intertwining SSI, SSDI, and how it all connects and how it could, each of them could impact the other. So Medicare and Medicaid start to talk about the caregiving, health insurance, medical expense side of these benefits, while the other benefits had to talk about a monetary amount to help support Joey. Medicare is a federal health insurance program that applies to people over a certain age, or this is the big takeaway, Joey, as long as Joey has been receiving SSDI for 2 or more years. I'm not going to specifically talk about Medicare like Medicare Part A, Part B, all of those types of things. It's way outside of the scope of what would be relevant, plus we'd be here forever. Just understand that Medicare is very strong health insurance. Also take it as a solid conclusion that Medicaid is not great health insurance. And I'm purely just talking about the insurance part of it. So if I had to choose which health insurance, just for the insurance part, I would prefer Medicaid or Medicare, I am picking Medicare 10 times out of 10. There's no scenario where Medicaid health insurance is superior to Medicare. Medicare is very analogous to your group health insurance that you probably get through your employer. It's that sort of superior health insurance. However, Medicaid provides other support that's beyond traditional health insurance. And that's where the value or the power in Medicaid lies. Medicaid could pay for the nursing home or the group home or in-home care or respite care or some other form of nursing care. These are the high dollar items. A group home with full-time nursing care could easily reach $5,000 to $10,000 a month. Unless you're able to privately fund that, Medicaid is your guardian angel in that regard. It's what's going to allow for those expenses to be paid. But I would not rely on Medicaid health insurance. A person can have both Medicare and Medicaid. So the Joey scenario that was receiving SSDI for more than 2 years will also be eligible for Medicare, but also could be holding on to his Medicaid eligibility that he's always had. And that's totally fine. Medicaid will just be the payer of last resort. So Medicaid will first go look at Medicare to cover the medical expenses, and then Medicaid will take care of what it can. Actually, if Joey is on some kind of group health insurance through mom or dad's employer's health plan, they can still have Medicaid. And the cool thing about Medicaid is Medicaid might actually even pay for the copay of whatever that group health insurance plan required. So there's a lot there that you need to understand how important Medicaid is. I should have said, if you apply for SSI and you become eligible for SSI, you're going to be eligible for Medicaid. It's not going to be like, oh my God, I got denied on Medicaid. but I'm on SSI. It's just you got to remember to still apply for Medicaid. Now, you might lose Medicaid if you blow the resource test and the door gets locked. However, the door can be closed, but still unlocked, which means you're not receiving SSI payments, but you're still Medicaid. You're still receiving Medicaid benefits. And the promised land for public benefits, where you want to ultimately try to get Joey at, is having Medicaid, having Medicare, and receiving some form of SSDI payments. Forget about SSI. At the end of the day, if you can get those trifecta of public benefits, some financial need based, some not, in my opinion, that's the promised land. That's where we want to get. And then you want to make sure you don't disrupt that autopilot scenario by making sure you don't somehow lock the door inadvertently. Any questions so far, or any more questions?
Yeah, we have 2 questions that just came in. First one, any suggestions for which order to even start with applying for Joey's benefits? Let's say he is 18.
Well, if a parent is eligible, get SSDI going as soon as possible, because it's the best financial, best monetary benefit, because it's unrestricted and all the things we talked about. But my guess is, in asking the question, you might not be SSDI eligible yet because the parents are not deceased, disabled, or retired and drawing Social Security. If that's the case, I'd apply for SSI, get through the SSI hurdle, and then apply for Medicaid or do them together. And then make sure when eligibility is met by a parent that you switch over to SSDI.
And then the second one is best way to apply for benefits. Is it online, in person? Which
Yeah.
is most effective in your experience?
Yeah, that's a great question. People do it in all ways and always get to the same path, maybe eventually. But here's kind of what I do, or what I advise my clients to do. It seems to work the most. It involves playing the dumb parent card a little bit, okay? Because that's what gets people's guards down. That's what gets people wanting to help you. The more invested they are in wanting to help you, somehow the better results come. And again, remember I told you it's chaos. It's not a perfect system. So anyone that's looking for like bright line rules and 100% certainty, you're not going to get it here. But what I tell my parents is make an appointment with one of the Social Security offices. I like the one in South County. They do a pretty good job. I've gotten good feedback. It's on Lindbergh, I believe. But anyways, make an appointment. It's virtual, it's physical. I mean, I can't keep up now, but make an appointment, play the dumb parent card, and tell them, hey, I have lovely Joey here. Joey's getting ready to turn 18, or he is 18, doesn't have any assets, not able to work. He lives with us, but we just got into a lease agreement between us, so he owes us money, and I just need help figuring out what to do and how to apply for SSI and Medicaid. SSI in particular in this conversation. And then they will walk you through an application process. Okay. And I have found that to have sort of the best results. But by the letter of the law, you could just go online, and you can go online, you can click on a link, you fill out the form, and it's supposed to give you the same result in either scenario. But for whatever reason, I find that the first idea gets a little bit more than the other one. And so that's why I would suggest that.
Thank you. And then we have Another one. At what point should parents seek the advice of an attorney in the benefits process? Only if denied benefits you believe you are eligible for.
Maybe before 18, but not, I don't think if you have a 6-year-old, I don't think you need to let that weigh on you. You have plenty of other things to focus on and stress about, I guess, in parenting. So I wouldn't, but maybe like once they're 16 or 17, um, I have them even as soon as a couple of weeks away from the 18th birthday, which is all fine. Part of it is putting a puzzle together so that your application is the best looking application. And life gets sticky and messy. And so there's a 529 account, or there's a couple of dollars in a savings account, or Joey has this or Joey has that, and no one's thinking about any of these things. Or, yeah, I have a custodian account or a uniform transfer, the Minors Act account, because that's where I've been depositing his birthday money that grandma gives Joey, whatever the case may be. Or, yeah, he lives with me and I am not charging him rent. All of those types of things. The more ducks in a row you can put before the application is going to give you the best chance to be approved, most important, and two, the best chance to get that door to open the widest possible. And I think you do not need an attorney to apply for these benefits. In my opinion, that's a waste of your money. As much as I like getting paid to provide legal services for my clients, I don't like taking money when I don't think I'm giving the value for it. So I would rather you come and see me, for example, to help put the puzzle together so that you have the best picture when you're applying, but then you can apply for it yourself. It's not something that's not doable by moms and dads out there. They do it all the time and they do it quite successfully. Just make sure you're doing it with all your ducks in a row first instead of applying and then later on cleaning up, because once you have a set dollar amount, it's not that it can't increase year over year after you supplement for the annual reporting. It's less likely to happen. I do want to talk about something that's not so public benefit related, but I talk about this in all 100 or 200 presentations I've given. And it's very, very important because what I want to talk to you about is the ways that inadvertently end up locking the door. So I want you to be aware of common pitfalls that families are doing all the time. And I guarantee you, the vast majority of people listening to me, one of these pitfalls is going to apply to you. And I want you to hear it, and then I want you to solve it so you do not walk down the inevitable path of having that door locked. So the first of these ways is 529 plans, transfers to minor acts accounts, or custodian accounts. Remember what I said almost an hour ago when I said, if I didn't say it was excluded from the resource test, that means it's included. And notice I never said a transfers to the Minors Act account or a custodian account or an UPMA account or a 529 account. I never said those words, which means those accounts could potentially lead to locking the door for Joey in the event that you have any of those accounts or that those accounts rise above the threshold. And remember, I don't want you to remember the $5,000 odd number. I want you to remember the lower $2,000 threshold. Unstructured beneficiary designations. So I used to give this presentation live at the wonderful ARC facility where I'd make everybody go through this exercise where they raise their hand if a scenario applies to them, and everybody's hands would go up. And then I'd have to tell them anyone's hands that are up is running into a common pitfall. So I won't go through the fun exercise because we're virtual and I can't see you, but I will highlight what I'm talking about here. Some of you have life insurance. Some of you have 401ks, IRAs. A lot of you have some of those things through your employer, which you started working. When you're working, you went to the orientation or onboarding. They told you about the 401k or the employer life insurance provided or whatever. They make you fill out all these forms, and then you put on the beneficiary designation, my spouse, if you are married, and then underneath it as the contingent beneficiaries, oftentimes people put my children. Well, that's a problem because depending on when people die, that beneficiary payment could end up going to Joey. If that ends up going to Joey and it's above the threshold amount, you just lock the door. If you have life insurance outside of your employer, same thing. Read the beneficiary designation. What did you put on that beneficiary designation? The solution is, let's say I have Emily and Joey as my two children. And let's say I'm the audience here and I put my wife, and then I put, after my wife dies, I wanted to go 50-50 to Emily and Joey. Well, that's a problem because of why I just said. All of a sudden that money goes to Joey. Boom, disqualification or locked door. Instead, the solution requires that I should write 50% to Emily, and then I should write 50% to the special needs trust for Joey. Now you got to go create a special needs trust. Almost anyone that wants public benefit eligibility for Joey is going to need a special needs trust in some fashion. I remember I'm not going to talk about special needs trust. There's many different types. There's some that are very affordable, that are done through almost quasi-governmental organizations. And then there's the more private-based ones that are much more customized to meet your needs, that are law firm drafted or lawyer drafted based. And then there's different types of special needs trust, which we won't get into. My point in saying that is really that's the solution. That's how you're going to avoid that door from being locked. The third one is directing funds to be held informally by another family member. So that I could put 100% to Emily. And I just know in my heart of hearts that Emily is going to take care of Joey. And maybe that's true. Maybe that is what Emily is going to do. I don't know if anybody can guarantee it, but maybe it is true. And Emily's a sweetheart and she loves her younger brother, Joey. And so she is going to do that. But what happens if Emily gets married and then maybe gets divorced? Or what happens if Emily gets in an accident and is in a lawsuit? What happens if Emily has children of her own and has financial hardships and now is torn with using some of that money for her own children instead of Joey? Or what happens if Emily's in financial problems and she has to file for bankruptcy? Here are all things where Emily loves Joey and wants to take care of Joey, but you have created vulnerability to the amount of money you left Emily that was supposed to be informally held for Joey. I am very adamant. Disinheriting Joey is the worst kind of planning you could do. I think it's just, I obviously I'm very opinionated about this. I think it's absolutely almost disgusting if I have to use a very harsh word. At least I want you to think like that now that you know why. Maybe you did it originally, because you just thought, hey, I don't want to lose Joey's benefits. You're much better off leaving Joey's inheritance or beneficiary designation money to a special needs trust and naming Emily to be in charge of the special needs trust for Joey. At least that way, what could go wrong in Emily's life won't impact what would happen to that money that was carved out for Joey's care. Gifts from non-parents is another pitfall. Grandma, grandpa is going to leave Joey some money through their own estate planning, or they just want to leave a gift. They don't think about it. They just say, hey, everything, $100,000 is going to go to Joey. And that's what they write down in their will or their trust or their estate planning documents. And then grandma and grandpa die. I mean, they had a wonderful heart to want to take care of Joey, but a really terrible consequence because they just locked the door to the benefits. So now that $100,000 is getting churned and spent for things that the government was already paying. So gifts from non-parents. Now, what's the solution there? Honestly, I think the solution there is that you have to have proactive conversations with your non-parent family members. You need to just ask them, hey, are you planning on leaving Joey money? A lot of them will say, no, I'm going to leave it to you. And then when you die, it'll go to Joey. Well, what happens if you die first? Then it would go to Joey. So there's, the conversation is very important. And if you find out some other family member does desire to leave Joey money, that's a good thing. And if you do find that out, you're going to need to create a special needs trust that is already available and ready to receive that money when it comes. And then you need to tell that family member to modify their documents to say whatever goes to Joey needs to go into that particular special needs trust. And then that will solve the problem. That will eliminate that door from being locked. The last one is moms and dads that are on the call. If you yourself do not have your own estate plan that says where things go, you're going to run into a problem. If you do not have that kind of plan in place, the state of wherever you reside has written a will for you. And that will says, when I die, half of my assets go to my surviving spouse if I have one, and the other half or all of my assets, if I don't have a surviving spouse, will eventually go to my children, Emily and Joey. We have that same uh-oh moment because now Joey received assets and the door is locked. So these are things I see happening all the time that's walking people down the inevitable path of disqualification of public benefits. I want you to know which ones apply to you, and I want you to tackle those issues so you don't have an inadvertent disruption on what I was calling that autopilot or that promised land of benefits. So that is, in essence, the presentation that I wanted to give on public benefits today. I'll leave with this thing. I've done it again every ARC presentation, and if anyone, I know some of you attending this are actually clients of mine, and so you've probably taken advantage of what I'm saying. I offer a complimentary, very customized about you and your family meeting, call, virtual meeting, whatever your preference is, to help you understand how things are going to apply to you and Joey specifically for you. At no cost. I just sit down, I'll meet with you or whatever. because that's what I've done for any audience member at any art presentation I've given. And so if you really want to master what specifically you need to do for you, or to make sure you're not getting ready to walk down the path of a pitfall, hit me up. We'll have a sit down. We'll talk about it. It's purely education. If after that you wanted to actually hire us to do something, that's up to you. Or you can go back to your current lawyers and ask them to do it. But I ultimately, it's about really making sure you understand what you could be doing for your Joey. So if you want that, just call and we'll schedule it.